We dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.
The Supreme Court heard oral arguments on a case against the Securities and Exchange Commission that essentially accuses it and other government agencies as acting as judge, jury, and executioner. Now, is the accusation a stretch too far, or does it describe a specific set of legal circumstances that seek to evade constitutional responsibility? Well, we're very fortunate to have with us Mr. Scott DeCosenza, who is a legal affairs editor of LibertyNation.com, host of the excellent Uprising podcast, and who also happens to be a constitutional attorney. So if he gets things wrong, we blame him. Scott, thanks for being here.
Thank you, Mark.
Welcome to the Thunderdome once more. So, Scott, tell me about this case that's before the Supreme Court.
Yes, this SEC v. Jarkozy. The name is a little one I had to practice there. This was a man who started a hedge fund and was accused of fraud by the SEC and had to pay, or was ordered to pay over, or at about $1 million worth of fines and restitution. And he challenged it because he said that they didn't bring him to court and say that he did this and give him a chance to defend himself. Instead, they just used an SEC in-house judge called an administrative law judge, or ALJ, to conduct the procedure, which was without a jury. And he said this violates a host of his constitutional protections, namely a Seventh Amendment right to a jury trial, and this is a civil matter, not a criminal one, and also that the independent federal courts, or Article III courts, which we would call them, need to be used by an agency, not their own in-house sort of Star Chamber would be the defendant's way of putting it. Now, obviously, that's not the government's position, but.
Well, now, the reason this one's so interesting, Scott, and it's something that you and I discussed while discussing the title of your excellent article on this on LibertyNation.com. And yes, I still think my title was better. But it's that it's not just the SEC that has these in-house judges and therefore decides things. The agency is essentially acting as the judge and the jury and the executioner, as in dishing out the fines and or penalties.
The best reporting I've seen puts it at about 30 agencies that do this. Now, the SEC is a quote-unquote independent agency, which is a bit interesting. What that, the president of the United States appoints every member of the SEC. It's designed so that there will be no one presidential term will appoint all of the commissioners because of their staggered terms. So the idea is that you didn't easily 2 terms in office to appoint the entire 5-member commission, and also only 3 of the members may be from the same party. So even if it's a Democrat, like Obama has 2 terms in office, he can not appoint a Democrat to 4 or 5 of the positions. Now, of course,
Scott, if I may interrupt here, Scott,
yeah, go ahead.
I think that point is largely irrelevant, isn't it, when it comes to the constitutional issues at hand, whether they're biased, whether they're unbiased or not. The fact is that people are being denied their 7th Amendment right here. And I think that's the big thing, isn't it?
One of the constitutional issues present, Mark. There are 3, but the court is
wait,
looking at.
There's more.
Okay? Yeah. And one of those issues is the independence of the administrative law judges, who the courts have said get special protection because of the quote-unquote independent nature of the SEC. Unlike another department, they can't be dismissed without cause. They have a for-cause protection for their employment. And that has also been extended to the ALJ, or administrative law judges, not just in the SEC, but in all of the other federal agencies that use these sorts of things. And they've said this is not okay. You have to be able, the president has to be able to dismiss these people without cause.
Yeah.
Just like they would any other political appointee.
So the person under the hammer doesn't get a jury trial. The people who are deciding his fate are essentially unaccountable, as in it's near on impossible to fire them.
Let me just stop you there, Mark. I apologize for the interruption. They're accountable to their employers, the SEC. Who do you think they want to stay in good stead with, right?
Yeah,
that's part of the punishment.
And there's a third constitutional issue here as well, isn't there, Scott?
Well, the other constitutional issue has to do with whether or not the SEC has the power legally or constitutionally to bring these charges in their in-house courts rather than take them to federal court, which is how the sort of limited government liberty activists wish that the federal government, how they would proceed, which is to say that if somebody breaks a law or a regulation that is important enough to generate an enforcement action, that enforcement action be adjudicated by the independent federal courts that are supposed to stand between the government and the people as a bulwark of liberty and make sure that due process and norms within the law are followed, which, you know, I'm smiling because you can imagine if you're the SEC judge working at the SEC, employed by the SEC, having lunch with all the people that are bringing you cases, you know, at the SEC, and they're the ones you see every day. And then there's this other person who comes in who those people have said is a bad guy, a fraudster. Who are you likely to, you know, to judge for? Well, the prejudice is baked into that system. And that's one of the other constitutional arguments, and which is why, Mark, this is such a huge case at the court for kind of like pro-government advocates versus limited government advocates, because all of those three things could be big deals if the court decides to rule on each of them in a way that is either beneficial or hostile to the position one holds.
It's a very emotive case, this, despite being about the SEC, which of course is a monolith, right? It's a very emotive issue because the idea that, you know, you can have a trial by jury, which means that human beings with consciences will be considering what your situation is, what the facts of the matter are, and then you're being judged by a jury of your peers. But not here. You're being judged by an employee of the agency that is prosecuting you. Now, Scott, this seems like the people who talk about the deep state. I mean, I hate to go down that particular rabbit hole, but isn't this precisely their definition of a deep state agency?
If you look at the universe of people that have filed friend of the court or amicus briefs in this case, one of the ways to judge, you know, the level of interest in the case is to just look at the sheer number of those. And this has been heavily briefed. And it is all sort of limited government advocates on one side and sort of big government advocates on the other. That's how it comes down. Those who argue for the rule of law and taming government want the government to be tamed by requiring the imposition of jury trials and the independent federal courts rather than, you know, you'll see these arguments, Mark, that it's, you know, more efficient for the government. And it's like nobody's arguing about the efficiency. Of course it is, right? I mean, yeah.
The only way the government can ever be efficient is if it drags everything in-house and gets rid of your constitutional liberties.
Yeah. I don't think that any of the founders argued that maximum efficiency was their goal with
that's the goal, right?
Yeah.
Okay, so obviously we don't have a ruling on this yet. Certainly not at the time of recording, probably not for quite a while the justices deliberate on this. But if they do decide that all three constitutional issues are a violation, I mean, this means that the entire, not just the SEC, but all the other up to 30 government agencies need to completely be redesigned from the ground up, doesn't it?
Well, their enforcement needs to be completely altered, and they need to then instead of like they did, and I'm searching once again for the gentleman's name, Mr. Jarczy. They would need to instead, for instance, so let's take Mr. Jarczy's case as an example. Instead of deciding to try that case in an SEC court, they would have had to have an SEC lawyer or the Department of Justice through a referral go to federal court and say, we want to initiate an action against this man in court. He would then have all the rights to a jury trial that, again, this would be a civil case. So it's not a beyond a reasonable doubt standard. It's a preponderance of the evidence standard, but they'd have to meet that before a jury rather than just a judge, again, who is employed by the agency that he's being prosecuted by.
It seems as though this is a case that has been waiting to happen, Scott, in terms of freedoms and constitutional quandaries and conundrums. So we will be watching it closely, and Scott DeCosens will be covering it on the pages of libertynation.com, or perhaps even on the Uprising podcast, which is always great. And I do recommend you listen to it wherever good podcasts are provided. Thanks very much, Scott.
Thank you for the plug, Mark. Always appreciated.
We dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.
Don't get caught up in the media madness. Join our movement for free thinking and free speech at libertynation.com. Publishing news and analysis 24/7 with original articles by our team of authors who tell it like it is. Join us each week for online TV shows, The Uprising Podcast, and Liberty Nation Radio. We believe in free thinking and free speech. We are libertynation.com.